I welcome you back to the course on gender justice and workplace security. In the last lecture, we tried to understand the laws as well as the procedural issues with regard to the offences specifically relating to women, such as the offence of rape, etc. And then the role of the police and the judiciary. As we said, the judiciary plays a very important and significant role in upholding the rights of women, and over the years, specifically since the 90s, it has been seen that in different cases the judiciary has tried to emphasize on the concern with regard to the rising violence against women and lay down principles whereby her rights, her dignity can be safeguarded, and the strict punishment can be given in cases where there has been brutal perpetration of offences against women. We will try to look into some of the decisions which have been given. There are a number of them or hundreds of them, but some of them with regard to specifically the offence of rape, etc., I will try to discuss. Now, this is one of the decisions of Pushpanjali Sahu versus State of Orissa, where the Supreme Court stated that sexual violence is not only an unlawful invasion of the right to privacy and sanctity of a woman, but a serious blow to her honor. It leaves a traumatic and humiliating impression on her conscience, offending her self-esteem and dignity. Rape is not only a crime against the person of a woman, but a crime against the entire society. It indelibly leaves a scar on the most cherished possession of a woman, her dignity, honor, reputation, and not the least, her chastity. It is a crime against basic human rights and violative of the victim's most cherished of fundamental rights, that is, right of life, contained in Article 21. The courts are therefore expected to deal with cases of sexual crime with utmost sensitivity. Such cases need to be dealt with sternly and severely. The significance of this laid down by the court of these words pronounced by the court assumes significance in light of the fact that if one looks into decisions given by the same court as well as the high courts in the 60s, in the 50s, in the 70s, one finds an appalling sense of degradation so far as woman is concerned. There are many such decisions which have gone on to shock the conscience of the people, in a sense that it has severely castigated the woman, questioned her character, questioned her every action with a sense of disbelief, and thereby sort of tried to dishonor and disrespect the woman in terms of the decision making. So, when the court recognizes the fact that the offence of rape is one which goes against the entire the sanctity of a woman, leaves a scar on her dignity, honor, reputation, and violates a victim's right to life under Article 21, it shows that the court is now cognizant of the fact that rising crime is a reality, the interests of women need to be protected, and the continuing crimes against women are indicative of the fact that the society has still not accepted woman as an equal partner with men in the development of society. Moving further, in Narendra Kumar versus State, a 2012 decision, the court said that even a woman of loose morals and easy virtue has the right to protect her dignity. Her evidence cannot be rejected on that ground alone. As I said, in many situations, the reputation of the woman was called in question specifically by the defense, and efforts were made to show that a woman is of loose morals. So, therefore, the court has clarified that even if a woman is a prostitute, she has a right to say no, she has a right to exercise her consent, withhold her consent, decide as to what to do and what not to do, and just because she is such a woman does not mean that any claim made by her is to be rejected. A very significant matter when it comes to offences against women is that the woman is seen as a accomplice to the crime, accomplice meaning a partner. Now, in general cases or in general offences which are there, whether speaking of murder or with regard to kidnapping, in no situations do we see this type of an allegation that the victim must have colluded with the perpetrator in the commission of the crime. Very strangely, whenever it involves woman and the woman becomes a victim, it is very easily remarked that she must have colluded or she must have partnered in the crime in question. Like very often we might have heard that in case of, let us say, a sexual harassment or in case of a sexual assault, that she has provoked the man, she has dressed up in a manner which was provoking for that man. So, these are common everyday experiences which we have seen for ourselves, or we have heard, or even maybe read in books, papers, etc. So, that is where in one of the cases or in several cases the courts have gone on to say that when we are speaking of such a victim, she is not a partner to the crime, she stands at a much higher pedestal than an injured witness. So, therefore, whatever she says, her testimony must be respected, and there should not be unnecessary corroboration or confirmation of the story which is asked for, because she is a victim of the situation of the act in question, and she is not a party or a partner in the crime which has been perpetrated on her. So, she cannot be held responsible in any way, but rather it is the act of the person, that is the accused, who is solely responsible for having perpetrated the act. As previously we have mentioned that medical examinations in cases of sexual offences are a very significant issue, as well as a very nightmarish experience in most of the cases. In the previous lectures with regard to the POCSO Act 2012, I mentioned that the act and the rules make way for medical procedures which are safe, convenient and comfortable for the child. Now, the same is to be extended or must be extended when it comes to other girls or women who become victims of sexual assaults or rapes in question. Now, specifically there is many times what is referred to as a two-finger test, which is taken recourse to in order to understand that whether the woman is habituated to sexual intercourse. However, this test has been found or has been held to be a serious infringement of the privacy of a woman, as has been laid down by the court in Rajesh versus State of Haryana, a 2013 Supreme Court decision, that the two-finger test and its interpretation violates the right to rape survivors to privacy, physical and mental integrity and dignity. medical procedures should not be carried out in a manner that constitutes cruel, inhuman or degrading treatment. The state is under an obligation to make appropriate services available to survivors, and proper measures must be taken to ensure the safety and that there is no arbitrary or unlawful interference with their privacy. So, yes, medical tests and medical evidence is very crucial and important in a rape case, but it is important that the judges, that the doctors, the other medical staff who are involved in examination of such women exhibit some amount of sympathy, some amount of consideration towards the cause of the woman, perform the procedures which will establish or otherwise indicate towards the commission of the offence, but not to show that whether she is habituated to sexual intercourse, which essentially the two finger test is only capable of. It does not show anything more other than whether the woman has been involved in such acts with other persons, but it nowhere goes to show whether she had been subjected to rape. So, that is precisely where the court intervened and said that the test which is being spoken of invades her privacy. There must be a better test, a better medical procedure which must be in place, and there should be a proper way in which such tests are conducted, so that the woman is not further humiliated and degraded. And to that extent, the Ministry of Public Health has compiled a compendium with regard to the tests which are to be conducted by government hospitals, etc., and that has been circulated all over. Now, in a case of rape or attempt to rape, the conception of compromise under no circumstances can really be thought of. These are crimes against the body of a woman, offences which suffocate the breath of life and sully the reputation. Any kind of liberal or thought of mediation in this regard is thoroughly and completely sans legal permissibility. So, that was Sham Narayan versus State 2013. This decision is significant because we are probably aware of the fact that in many states of the country and in many communities, if such an offence is perpetrated on a girl in the family is virtually made outcast by the entire society. Her chances of marriage suffer, and she finds it difficult maybe to continue with her life in terms of her education, in terms of her career, because the entire society shuns her, makes her responsible for the act that has befallen her. And therefore, in many situations there are increased efforts which are made so that the girl can marry the perpetrator, and on that basis there are efforts made that any case which has been instituted on the basis of the compromise, such cases can be done away with, can be dismissed. And in many cases it has been seen that actually courts have allowed for such compromises, allowed the perpetrator or the accused to go on to marry the victim, and on that basis dismiss the cases. This is an unfortunate situation because the law and the procedure nowhere allows for such manner of dismissal of cases or any manner of mediation, specifically where it relates to offences of this nature, sexual assault of the nature of rape. And therefore, the Supreme Court in 2013 made it very clear that there can be no situations of compromise, of conciliation or mediation between the parties. Now, while speaking of sexual harassment at workplace also, that is why the significance of the fact that only in those cases, only if the victim asks for conciliation can conciliation be spoken of. It has been made clear in the previous lecture that she cannot be coerced, she cannot be intimidated by the internal complaints committee, by the other party or the employer or anybody to agree to such a conciliation. So, that is very important. What is that the woman wants, but when it comes to criminal law, it cannot again be what she wants. Even if she wants to marry the other person, that cannot be a ground for dismissing the case. If there is an allegation and the allegation is otherwise established, then the person has to be held liable and criminally responsible for the act which has been perpetrated. Now, these are there are two other landmark decisions. There are many others which have tried to specifically lay down some guidelines when it comes to rape of minors, or more specifically speaking of child sexual abuse. So, this is one case of Sudesh Chaku versus KCJ, where the court laid down certain guidelines, because in those cases you have a minor who is before the court and the minor finds it very difficult to narrate the type of incident. There is a serious it affects the child as such, and if there are questions put to such child, the child becomes further more fearful and becomes silent, and it becomes a very difficult situation to handle or to even to proceed with the case. So, therefore, some of the guidelines which were laid down, where defense counsels are expected to avoid needless abuse and harassment of the witnesses. The trial judge shall handle the proceedings with considerable sensitivity and ensure that the trial is fairly conducted. Questions are not complex or confusing. Breaks during questioning need to be given to the witness. If the prosecution establishes that to obtain a full and candid account from the child witness, a screen is necessary, then such screen as would screen the witness or the child from the offender, such a screen has to be placed between the parties, and the child should be visible to the judge, or the witness should be visible to the judge, but the witness should not have a chance to have a face to face interaction with the other party. Proceedings should be in camera. The trial judge may allow a supportive person like a social worker or other friendly but neutral party to with the child, or even sitting beside a young child who is testifying. So, these are certain important guidelines which are to be maintained when there is a child witness or a minor who is before the court testifying with regard to the incident in question, and specifically where it relates to incidences of violence against women. So, the girl child should specifically allow these type of safeguards, so that she is not further put to abuse or humiliation. This was another celebrated case of State of Punjab versus Gurmeet Singh of 1996 Supreme Court, where the court laid down further guidelines saying that the courts should not pass unnecessary remarks on the character of a prosecutrix, should make sure that the cross examination does not become a means of harassment, privacy of the prosecutrix is maintained, and preferably female judges are appointed in trials. So, this is one of the very landmark decisions. The reason is that this was for the first time that the court recognized the fact that many times the rape trials become a situation where the woman's character is assassinated, where she is put to test rather than the offender who is being tried, and it is her character, her behavior, how she conducted herself becomes the core point of questioning for the law and decision making process. So, that is a very unfortunate situation, and to do away with that, the Supreme Court headed by Justice J.S. Verma and Sagir Ahmed went on to state that unnecessarily statements on the character of a prosecutrix, saying that she is a woman of loose character or she is of such nature, these things should be avoided. The court must be unbiased impartial and independent, and it should not make any loose comments against the victim. Similarly, as I have said in the previous lecture, the courts have a responsibility in the conduct of the trial. Their sole responsibility is to hear the parties, the evidence, and to give decision, but in the conduct of the trial, though the system requires it to act as an umpire, it must intervene as and when it is required. So, if it is seen that obscene questions, objectionable questions, or questions invading on the privacy of a woman are being put to, then the court can rightly intervene and stop some such questions, because cross examination does not mean that it is a means to harass the woman. Furthermore, the privacy of the woman must be maintained, and preferably female judges, and that is where its impact is seen when we look into the composition of the ICC etc. in the Sexual Harassment at Workplace Act. They are headed by women. The purpose of having a woman is to ensure that the woman is aware of the concerns of the other woman, and she can better respond to the situation that the woman is in. So, therefore, even in cases where women offences relating to women come in question, so far as possible there should be women judges who look into the matter, and even in cases where the police is dealing with women, it is preferable that it should be through women police officers that the matter is being looked into. So, these are few of the judicial decisions in these matters which have been put before you. As I said, there are several other judicial decisions, and the courts have made right interventions since the 90s in order to uphold the rights and dignity of women, and in all such cases the courts have tried to see that through the decisions there can be an overall improvement in the societal perception with regard to these offences, as well as the legal protection which is given to them is effective, and there can be a better upholding of the rights of the and causes of the woman. So, therefore, within the criminal justice mechanism, the police have a very significant role to play, and they are supposed to be sympathetic to the cause of women, and that is where women police officers further become important, and they are to accept complaints, act on that complaints. There are various other rights which have been ensured under the criminal procedural law, and then there are the courts. So, whether it is the criminal courts deciding on the issue or the higher courts, in several cases for that matter, we have seen that they have played a remarkable role in upholding the rights of women. Now, so where there is at one place this legal framework which is there with regard to gender violence or with regard to the rights of women, on the other hand, there are the different agencies which have been set up in the society, and these agencies have also undertaken various initiatives and various important steps in order to ensure that the rights and cause of women can be effectively protected under the law. Now, when we are speaking of agencies, there are different bodies, institutions in the society as such which are working towards the cause of women. Now, we know that at the central level, at the state level, there are the governments and the relevant departments of the government, such as the Ministry of Women and Child, whether at the central level or at the state level. Now, these departments are constantly endeavoring to protect the rights of women, through various through the enactment of various laws from time to time, through various policies and programs which are being floated for the purpose. So, we might have heard in the last few months or years about Beti Bachao Beti Padhao initiative, which has been taken by the ministry at the central level, or maybe if I speak of the state of West Bengal, the Kanyashri scheme, which has been taken by the state of West Bengal and which recently won a United Nations award. These are extremely positive steps which have been taken in order to address maybe the issue of education, to address the issue of early child marriage, to encourage children, specifically the girl children, to continue her education at least till the age of 18 years, and to ensure that girl children are not put to death by giving certain financial incentives to the parents or to the child as such. So, there in that manner, this is just an illustration. In that manner, these government bodies have taken ample initiatives over the years to address the various gaps or various weak points which are existing, and to see that the issues of women can be effectively addressed. Other than that, there are the different other bodies, specifically the National Women's Commission and the civil bodies which are existing in society, and in the next lecture we will discuss the work of these bodies in protecting the cause of women.